Hello, welcome, and thank you for being here. My name is Jeff Mersacci. I am a life and estate planning attorney in Raleigh, North Carolina, and I have been getting flooded with questions about domestic partner legal documents and what exactly is the effect of the newly enacted Amendment 1 in North Carolina. Well, this is an attempt to just sketch out exactly what's going on as precisely as we can, because the big thing about this amendment is we are not exactly sure what it means. That was actually part of the history in even getting this amendment on the ballot as an initiative, is the legislators who voted in favor of it didn't even really know exactly what it meant, and they anticipated that there would be lots of litigation to flesh out exactly what it was. Yes, that sounds ridiculous, but that's exactly what happened. Now, the pertinent part, marriage. Marriage between a man and a woman is the only domestic legal union that shall be valid or recognized in this state. Those are the three important words: domestic legal union. And the fact that the state is what is recognizing this. Okay. What does this mean? What exactly is gone? All right, first, domestic partnerships for municipalities should pretty much be gone. Having municipalities that hire workers and say, okay, we will allow you to register a domestic partner, and then your domestic partner can have survivor benefits on your pension. They can receive health insurance as part of a family. Because that domestic partnership is a legal union, that's where we're going to have some issues. Now, I can tell you at the time this is being recorded, Durham County and, and the town of Chapel Hill offer partner benefits, and both of them have said, despite the amendment, we are going to continue to provide those benefits. We'll see what happens with that. Almost certainly there are going to be lawsuits. All right, so what else has gone with this amendment? A recognition in the law of unions other than married people in domestic violence statutes and protective orders. Here is where statutes defined relationships between two people in order to provide more strict and stringent penalties for domestic violence. So, in other words, if you had boyfriend, girlfriend, or for that matter, boyfriend, boyfriend, girlfriend, girlfriend, and there is physical abuse in the home, that's domestic violence. But that relationship between the two parties is defined in the statutes. So it's very likely that that's going to get thrown out. Now, it was, with very similar language, thrown out from another state. It took 2.5 years before the state Supreme Court actually heard and ruled on the matter. They eventually kind of carved out some interpretive exception, but it really was kind of a stretch in order to save the domestic violence laws because it became such a big issue. But there's no guarantee that will happen here. And the whole point is, well, all right, how many people have to be battered before it's a big enough problem that they say, okay, this is an exception. All right, and recognition of a relationship or a union in legal documents is now suspect and open to interpretation. This is where it becomes a big issue for a lot of domestic partners who put together estate planning documents. And that's primarily where I'm getting the questions, because I am a life and estate planning attorney. I've written, now I'm on the third book has come out on domestic partner planning. So here are the questions. What's going on? What do we have to do? All right, let's step back and just take a look and see what are the goals that most partners have, and how does Amendment 1 actually affect the solutions that are out there? All right, typical partner goals that we can address: bringing property together as a couple under one roof, basically creating our plan. The big way that we usually do this is for revocable living trust planning. You can do a joint trust for domestic partners if it's done the right way. I know a lot of attorneys out there say, oh, you can't do that. Well, you can if you do it the right way. The big thing is this bringing together of property. It's not really a domestic legal union. It's just a bringing and collecting together of property. If this type of joint trust were to be found to be illegal under Amendment 1, then it means that any trust that has parties at all other than a husband and a wife, then the trust would be invalid. It would completely invalidate most of the trusts that are out there. I mean, if you want to leave something to your son in trust with your brother, so it's your uncle that's taking care of things for your son. Well, they're not married. Therefore, the trust would be invalid. It would create absolute chaos. I don't see that happening, specifically because it's not really a union, right? Second big partner goal that I usually see, empowering each other to make health and financial decisions in a crisis. Again, this isn't a union, it's an empowerment. You're appointing someone to make healthcare decisions for you if you get sick. It doesn't matter whether you're partners, whether you're married, whether you're brother and sister, whether it's just a friend, it doesn't matter. It's an empowerment. It's not actually creating some sort of union. It's an agency relationship, and that goes way, 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 way back in the law. So again, if this were to be determined invalid, then every single healthcare power of attorney, every single financial power of attorney would have to be invalid except between a husband and a wife. That's not going to happen. Plus, there is also federal law behind healthcare powers of attorney. Now, unfortunately, I hear lawyers get this all the time. I was actually a very prominent lawyer actually got this wrong on a conference call, and I didn't want to even say anything about it, but partners don't get to automatically make healthcare decisions for their partner. There was an executive order a number of months ago from the president stating that partners can now make healthcare decisions. In hospitals, you're going to lose your Medicare and Medicaid reimbursement if you don't follow those instructions. Well, part of that fine print is if you have a validly executed healthcare power of attorney under state law, then the hospital disobeying that power of attorney would end up losing Medicare and Medicaid reimbursements. They won't be eligible for those programs anymore. And essentially, there isn't a hospital out there, for all intents and purposes, that wouldn't financially go under within a couple of months if they lost that type of money. So that's not going to happen. All right, third big goal, providing an inheritance upon death. Once again, this isn't a legal union. Now, unfortunately, documents on inheritance, wills and trusts, much more often than not, I see this done wrong, and it comes out to really a point of laziness in the documents from attorneys, and they screw it up all the time. I've seen very typical standard wills that state, Jane Doe is my spouse, and all references to my spouse refer to Jane Doe. And then the rest of the document goes on to say, I give 100% of everything to my spouse. My spouse shall be my executor. So the spouse is only named once. All right, that's okay. But I've seen a lot of attorneys just say, oh, well, let's just make it partner. And so now Jane Doe and Janet Roe. Jane Doe is my partner, and all references are to her, and then the rest of the document has my partner or my domestic partner. That's where you could have a challenge. That's where it could be an issue. And in particular with a will, with things going through probate, that just makes it a huge landmine that you're putting right in the middle of the hallway, and you know you're going to end up stepping on it. There's no reason to do that. How do you get around this? Well, you don't use that term partner. You say, my executor is Jane Doe. My trustee is Jane Doe. I leave 100% of my assets and my inheritance to Jane Doe. It's not that complicated, but it's done wrong. So I'm just strongly urging all partners who are out there to have their documents get a second look at. And I mean, we do that all the time, and we'd be happy to do that. All right, so the other thing is, the only way that partners will not be able to leave an inheritance to each other through a will or a trust is if they completely invalidate all of the statutes that allow someone to leave assets through a will or a trust. You have to give it to your spouse or your next of kin. That's never going to happen. That would be huge, huge chaos. So again, that's not going to happen. All right, so what needs to be done to accomplish these three big goals? First, I strongly urge, get a good joint revocable trust with a property agreement. Now, I hear attorneys all the time, oh, you don't need a trust, do a will. Well, a will means your assets go through the probate court system. Once they're in the probate court system, they become extremely vulnerable to contests under the document. There's a whole court process set up around it. And the one thing that is virtually guaranteed, the attorneys get paid. So somebody says, well, my sister was with this person, she called her partner, and I don't agree with the fact that she's getting all the money. I should get it. I want to contest this. Attorney goes, well, sure, okay, let's give it a shot. The attorney's probably going to get paid out of the estate anyway. All right, well, what about with a revocable trust? How is that different? The assets aren't in probate then. If it's done right and the trust is funded, your assets are in the trust, not in probate. Now suddenly this court process isn't there. Now suddenly if someone comes in and says, my sister had a revocable living trust and she left everything to her partner. Well, as an attorney, I know that's not in probate. I know the chances of me getting paid from the trust are extraordinarily low. And so for me, in order to get paid, okay, fine, I need a $10,000 retainer, or give me the check and I'll get started. Usually the answer from people who want something they're not entitled to is, well, no, I'm not going to put up my own money to get it. So that's where there's a lot more safety, particularly with partners where there might be a relative that wants to say, I don't like this inheritance setup, it should be coming to me. Okay. Next document, a good healthcare power of attorney. This is just needed. And it's unfortunate that the administration took such a good step in protecting partner healthcare deciding rights by having it in a healthcare power of attorney and not emphasizing the healthcare power of attorney part. There are more couples now who think, oh, we've got this executive order from the president, we don't need a healthcare power of attorney. No, that's not what the order says. So again, you need that good healthcare power of attorney to have that right. A durable general power of attorney, essentially a financial power of attorney, is also needed. If you've got a trust, you're going to have most of your assets inside the trust, so your partner can continue as the trustee, no big deal. But sometimes there are things outside the trust having to deal with government institutions. That document also legally empowers to do that. You don't ever want to put an IRA or a 401k into your revocable living trust. So if it's outside your trust and your partner needs to access money from those retirement accounts, they need that power of attorney as well. Another document, a living will. And this is kind of optional. This is the should we pull the plug, forgive the expression. A lot of my clients know that if they get to the point where there's no hope of recovery. They just want their wishes in writing that the doctors should at that point withdraw life support and nutrition and hydration. Okay, well, that's what the document is. Some of my clients prefer to have their partner make that decision for them. All right, well, then we don't have a living will. The healthcare power of attorney kind of takes that role then. The living will kind of overrides the healthcare power of attorney. There's also a nomination of conservator document. I kind of call this like a backup document. This is in case you need a guardian. If you get to that point where you're sick for such a long period of time that a guardian needs to be assigned to you, well, now you've got the same people as your healthcare power of attorney. And that's just generally, it kind of makes sense. The main decision usually is nursing home care, in-home care, and the healthcare agent is the one who usually understands those types of decisions better. Well, it's really a backup document because you've already got a good revocable living trust with assets in it. You've got a financial power of attorney for the assets not in it. You've got a healthcare power of attorney. Usually you bring it to court and you say, look, Your Honor, we've got all of this covered. And even if you go through this whole ridiculous exercise, we've still got the conservator that the person wanted. It's the same as the healthcare agent. So it's kind of a way to try to cut off litigation. And then last, for the main documents, you do need what's called a pour-over will. It just says if anything ends up in probate, send it to my revocable living trust, and that'll take care of it. So from that perspective, it just pours it over into the trust. Well, why not just put all of the same terms and conditions for the trust in the will? Well, then because everybody sees it. And we're in an age where if there's public information out there, marketing people get a hold of it. And if marketing people can get a hold of it, scam artists can too. So the less information that's out there, the better. That's just a good general rule. Well, if the only thing in the probate file is the name and address of the trustee and not who the real beneficiaries are, people tend to leave it alone, especially the marketing people. They know they're probably not going to get anywhere. All right. So there's also things not to do. I've been seeing this increasingly happen. Joint property with the right of survivorship. No, 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 no. Don't do it. There are gift tax implications. I'll tell you where you can get more information on that. There's no need for me to go over it again with the other resources that are out there. But really, just joint property with the right of survivorship, it's not generally a good idea. It's simple. It sounds simple. It actually is simple. But you've got gift tax problems. You've got problems if you separate. If the relationship dissolves, it becomes gift taxable the other way if it breaks up. It's just not a good idea. Second, using a simple will or even any kind of will as your main estate planning document where all the action takes place. Again, particularly for partners and particularly in this type of climate, relying on a will, it's just not as safe as using the revocable living trust. Now, I'm not saying that we won't do wills if that's what you want. We give our clients the facts. Here's what everything does. Here are the pros and cons, and you make up your mind. I do have several partner clients that decide to do the simple wills. And generally, their families seem to be okay with the relationship, so they're not worried about contests. Okay, fine. That's their decision. And then third, I'm only going to use one example, but there are lots of crazy things out there. Oh, just put all of your assets into a corporation or an LLC. That avoids probate. No, it doesn't. You're just recharacterizing your property. If you put your car and your house and your bank accounts and your investments into an LLC, a limited liability company, and you pass on, well, then the shares and the interests in your company go through probate. And on top of that, it's a business entity. You have to file stuff with the Secretary of State's office each year. You have to pay a filing fee of $200 every year. And there's no lawsuit protection because you're not using those assets in business. So, you know, somebody just said, let's try to do something off the wall. Let's use an LLC as a estate planning vehicle. It's kind of like, you've got a dump truck. A dump truck is good for what it has to do, but it's not something you drive back and forth to work each day or take, on errands to the shopping mall and to the grocery store. It's just not suited for that. Well, limited liability companies are a good business tool. It's not an estate planning tool. Stop trying to fit a square peg in a round hole. It doesn't work. So, all right. And then finally, I just wanted to put some places to get more information. The good news for my clients, we haven't been using the term partner in our wills, in our trusts, in our other documents for years. So if the question is, oh, do I have to do something? Don't worry, we've already got it. We've been getting it covered. We haven't used that term partner, not because, 16 years ago when I started practicing law, I saw that there could be this constitutional amendment about legal unions. I wish I was that prescient and could see that far into the future. The fact is, the term partner in the statutes is a largely business term, and that doesn't properly describe the relationship, so let's just leave it out until it's an official term. So it just ended up that our documents are fine. So for our clients that are listening and seeing this, don't worry about it. You're set. If you need to make changes to your stuff, well, you should be getting in touch with us anyway. All right, now, how do you get more information? All right, in North Carolina, you can set up an appointment with me. We can send you information before. We send a kind of whole pre-appointment packet, which goes through different options. I'll send you one of my books with it, so you can take a look through that. Second, we have the Domestic Partner Planning Guide at partnerplanningguide.com. This is something that's been out for, I think, a little less than, well, it's been a few months before the amendment issue came up. So it's out there. It's an ebook. It's got a lot of good information. And on top of that, we've got 12 hours of audio interviews that go over other areas related to estate planning. Purchasing a home together, how do you handle things like that? How should state income taxes and federal income taxes be handled? What are some financial planning objectives for a lot of clients? So all of that's in there. Now, if you just want something more simple, you can get my book, Estate Planning for Domestic Partners. Nice, basic, and easy. Just go to theestategeek.com. Again, theestategeek.com, and you'll see it in there in the list of books that are available for sale. And then, okay, you don't want to spend any money. All right, that's fine. Go to RaleighDomesticPartnerPlanning.com and fill out the information, and you get signed up for a free mini course by email. We send you a series of emails, and there's an audio interview that you can download and get a lot of the same basic information. Not as much, but enough to see if this is where you want to go. So with that, I just want to thank you for listening to this and logging on. And I just want to let you know, look, Amendment 1 passed. Things have to be done to make sure you've got the right kind of planning in place, but it is by no means impossible. It's just got to be done the right way. Thank you.